not depreciate the very legitimate concerns raised any time a law enforcement officer uses deadly force against a citizen. My obligation is to look at the facts of every case like this, analyze those facts in the context of the criminal law, and make a determination whether a crime has occurred and whether that crime can be proven with evidence that would support a finding of guilt beyond a reasonable doubt. That is my ethical obligation and the obligation of every prosecutor in this country. I can be deeply aware of the very real historical reasons for concern, but I cannot be swayed by passion or prejudgment when making these decisions, regardless of how popular or how unpopular that decision is. This case occurred several weeks after a law was enacted that required an independent law enforcement agency to act as the lead investigative agency in police fatalities. That was done in response to the historical concerns that I mentioned before. The state's Division of Criminal Investigation agreed to act as that agency in this case, and I believe they did so professionally and independently. In the spirit of that law, I also sought out and received a completely independent assessment of the facts in this matter from a nationally recognized expert in the use of force by the name of Emmanuel Capelson. Our agreement was that he was to have access to any and all information related to this case, and he was to offer a professional opinion on Officer Manny's actions without any influence from me or any law enforcement agency in the state of Wisconsin. We also agreed that whatever his assessment was, that it would be made public as soon as reasonably possible after he completed his investigation and report. I received that report on December 17th, and after carefully analyzing the investigation, the forensic evidence in the case, the law, and the conclusions of both a local use of force expert and Mr. Capelson's report, I have come to the conclusion that criminal charges are not appropriate in this case, and I am releasing all of the information related to this investigation so that you, the public, can see all the facts related to this decision. I will now briefly outline what those facts are and explain them in the context of the law of self-defense, how an officer is trained to use force, and what the independent expert's assessment of those facts are. Now, as you came in today, I made available for you both the initial report from me, but there's also attachments that include the expert's complete report. It's a 28-page, single-spaced report. You have the complete report from Lieutenant Martin from the Greenfield Police Department, the local use of force expert. You have the autopsy report. You have the Wisconsin Crime Lab DNA results. You have the entire dispatch log from the Milwaukee Police Department, and any exhibits that I talk about today will also be made available to you. In addition, the Division of Criminal Investigation is prepared to release all reports related to this incident pursuant to the new state law. So all that information will be made available. Why don't we start off by going right down and analyzing it as I did in my report, and let's take a look, if we can, at the initial scene itself. If you can, just pull up the PowerPoint itself. Thank you. Flip to the next slide, right there. As you can see, this is a photograph that was taken on April 30th of 2014. This picture is taken from the 1000 Water Street building from an elevated view. It's a contemporaneous photograph. It was taken shortly after the incident had occurred and officers arrived. What's significant and what's relevant to the report is simply the orientation. So from this picture here, you were looking south towards the City Hall building. To your left on the screen is the MGIC building. To the right is Water Street. And then obviously you have the 1000 Water Street building to the south. Located right here is the Starbucks kiosk, and where the police officers are located in this location is where the majority of the incident occurred. Now, a detailed schematic was also prepared. If you go to the next slide, please. Detailed schematic. Now you're oriented to the north. What this indicates is this is the Starbucks kiosk. The location of Starbucks was under renovation at the time, and again, this is the orientation of Mr. Hamilton at the conclusion of the incident. His head was faced to the southwest at the conclusion of the encounter. Again, we did an extensive canvass of this entire area. What's significant to know is that there was no video surveillance footage that was recovered of this incident. There was one camera that was located in the NGIC building on the east side here that was on a panning rotation. It actually sees the police officers as they arrive shortly after the incident, but it did not recover, or it did not record the actual incident as it took place. And go to the next slide, please. And again, this is just a larger blow-up of that scene schematic, which indicates that numerous casings, total of 13 casings, bullets recovered from the scene, as well as Mr. Hamilton's personal items were recovered there as well. Next slide, please. Before I address the issues related to the forensic examination by the medical examiner, let's first discuss the initial dispatch of the Milwaukee Police Department. The initial dispatch occurred approximately 1:52 p.m. There was a call from Starbucks, and there was a request for service. That went to Officer Keith Cameron, who was acting as the District No. 1 acting sergeant at the time. Officer Manny at that time was assigned to a beat patrol in the downtown area. He was on assignment already in the Riverwalk area when Acting Sergeant Cameron contacted him. He left him a voicemail message. We were able to obtain that voicemail message during the course of the investigation. What it indicated is he received a complaint from Starbucks, and he reported to Officer Manny that there was a homeless man sleeping by the trailer next to Starbucks. That was the original report there. Because he couldn't contact Officer Manny, he left that voicemail message. He then created a dispatch for the dispatcher, and they sent the assignment to two police officers, Officers Forte and Officers Fitchett. Now, of note, that dispatch indicates a trouble with the subject. There's no mention of homelessness or anything of that nature. The dispatch itself simply indicates there's a trouble with the subject. Officer Forte and Fitchett arrived shortly thereafter. They encountered Mr. Hamilton. They determined that he was not causing trouble, and they left the scene. A short time later, they were contacted again by the Starbucks employees, and after that contact, they returned to the scene and explained to the Starbucks employees that Mr. Hamilton was not causing the disturbance, and they then left the scene. Approximately 3:28 p.m., Officer Manny gets his phone message and indicates that he has a assignment to Red Arrow Park. He contacts dispatch to find out if there was an assignment created for that location, was told no, there is no assignment there. He then puts himself on there. When he arrives is when the incident occurs. We then looked extensively at the forensic evidence related to this case. Of note, there was a total of 21 wounds inflicted in this encounter. Now, that's a result of 13 to 14 shots. Now, as you look at the expert's report, he says approximately 13 to 14 shots. We know with certainty that there were 13. We believe there were 14. 13 casings recovered on scene. The vast majority of the shots were to the exterior portion of Mr. Hamilton, with the fatal rounds occurring in the chest area right here. Of obvious concern to everybody has been the number of shots fired. We're going to discuss that extensively when I discuss the analysis that's done by the use of force experts, but if we can, I'd like to briefly go to the demonstration that we can show you that will simply demonstrate how quickly a firearm that's issued to the Milwaukee Police Department can be fired in a relatively short period of time. If you go ahead and play that.
For this demonstration, I'm going to load up the M&P 40 caliber Smith & Wesson. It's the same weapon P.O. Manny used. It's not his weapon, that's on inventory, but it's the same thing other than that you would have been using other than, of course, the serial number. I'm using the same ammunition that Milwaukee Police Department uses. This is Spear Gold Dot 180 grain bullet. There's 14 rounds in here. Police Officer Manny was at a fire position when he fired the 14 rounds, and I'm going to, under control, fire these 14 rounds as quick as I can from this weapon. I'm using a packed timer. The packed timer will record how long it takes me to fire, and will also start me with a beep so I can start the shooting sequence. After firing all 14 rounds, you'll notice that the gun is actually left in what's called a lockback position. I'm going to take the magazine out of the weapon. This is when an officer typically would reload. The weapon is now empty. I'll double check it and put it back into my holster. The timer recorded 2.99 seconds for all 14 rounds fired from this weapon. The first round took .30, so of a second, a little more than a quarter of a second to fire the first round. Obviously, P.O. Manny would not have been starting with the timer. The situation was fluid for him. So with that .30, I would have fired all 14 rounds in basically 2.69 seconds. And that concludes this demonstration.
I wanted to show you that demonstration before we address the next major issue, and that is the significant number of citizen witnesses that observed portions of this encounter on April 30th. We obviously were dealing with a situation in downtown Milwaukee at regular business hours, approximately 3:30 in the afternoon. You literally had hundreds of people both working and occupying that general public space when this incident occurred. The reason that's significant, again, is that we were required under those circumstances to try to contain that scene to the extent humanly possible, professionally possible, and to identify and interview as many of those witnesses as quickly as we could. By as quickly as we could, within hours, I'm talking about the Division of Criminal Investigation, the Milwaukee Police Department, and investigators from my office were videotaping and audio taping citizen witnesses and examining their recollections related to this incident. We broke the citizen witnesses into generally 4 categories: those who saw all or most of the encounter between Officer Manny and Mr. Hamilton, those who saw the last portion of it and identified Officer Manny as having fired 1 or 2 shots after Mr. Hamilton was on the ground, those who observed Officer Manny's reactions after the incident occurred, and those who observed, to some extent, the fact that Mr. Hamilton was observed with Officer Manny's baton, what they would have described as a wooden stick or what they believed was a baton at the time. In reviewing those, I want to make it perfectly clear. When we assess the statements made by the witnesses, we are not implying in any way or any form that one witness is more credible than the other witnesses. My experience in this particular investigation is that all the witnesses reported what they saw to the best of their ability to recollect. It was not a credibility issue. None of the witnesses had any personal knowledge of either Dontre Hamilton. Some of the witnesses, particularly those who were employed by Starbucks, had some previous experiences with Officer Manny. But the recollections that they provided were not influenced by anything other than their ability to recall to the best of their ability. Of significance is that at least 12 witnesses observed substantial portions of it, and in the report, I take the time to show you where they were located when they made their observations. What you had is essentially 360-degree perspectives of the incident in one form or the other. What comes out of all of those direct observations in that first category is A, violent encounter occurred between Officer Manny and Mr. Hamilton. B, during the course of that struggle, Officer Manny deployed his baton. C, during the course of the further struggle, he was disarmed of that baton. And then some of the witnesses observed Mr. Hamilton actually strike Officer Manny or attempt to strike Officer Manny. They also observed Officer Manny withdraw his firearm, and they heard him discharge the firearm numerous times. And again, as you'll see from the expert's report, none of the witnesses accurately records the number of shots fired. But that's why I wanted to show you that demonstration first. You have to ask yourself if encountering this unexpectedly in a public space, if you would realistically, even now, if you could honestly say that you heard 14 shots fired in that circumstance. The vast majority of the witnesses undercounted the number of shots fired. In fact, as the expert points out, there were Milwaukee police squads in the area as well. Even they had a difficult time identifying where the shots were occurring from because of the echoes that would take place in that particular physical location. The second category of witnesses indicated that, and the vast majority of those were located in the MGIC building to the east of the incident. They heard shots, they ran to their window, and they indicated that they believe they observed Officer Manny fire 1 or 2 rounds after Mr. Hamilton was to the ground. Now, this is of significance again, and at this point, if you can go back to the slide from the anatomical position. This is where the forensic evidence related to the medical examiner's autopsy is absolutely critical. And we spent a lot of time, both DCI and the independent expert spent a significant amount of time discussing these issues with the medical examiner. Of significance in the encounter itself is that there's a uniform belief that this occurred very, very quickly. That's consistent with the witness statements and other evidence that's collected. You'll see that a significant number of the wounds are located to the arms and shoulders, and that the fatal wounds occurred entering into the right side of the chest and entering Mr. Hamilton's body at a downward angle. Again, the downward angle itself, I want to make it perfectly clear, the numbers that you are seeing right here do not reflect a correlation between when Officer Manny fired his shots and when those particular wounds occurred. The medical examiner cannot tell you that, nor can the medical examiner tell you exactly where Mr. Hamilton was and where Mr. Manny were when they were engaged in their struggle. What they can tell you is the general path of that the bullet traveled, where it entered, where it exited, if it did, and the relationship of the entrance wound to the exit wound and the injuries that were caused thereby. It is significant, however, that it is a downward trajectory. The independent expert found that significant in that, in our experience, you have if 2 people are standing together and there's a discharge of firearm at a close range, that firearm that you just saw demonstrated shoots a bullet out at about 1,100 to 1,200 feet per second. Now, in that short a period of time, that's essentially a straight line. And if I could just briefly demonstrate why that's significant, if there's an encounter with 2 individuals standing, and there's generally a straight line, if this is the trajectory of the bullets right there, and even if there's a slight difference in height between Officer Manny and Mr. Hamilton, which there is, Manny is about 5'11", Mr. Hamilton's about 5'7". Any rounds discharged, you could see if they're standing like this direction, those rounds would essentially, if this is Mr. Hamilton, they would be in a downward trajectory. If, however, Mr. Hamilton was on the ground when those shots were fired, you can see that the trajectory would generally be ascending at that point in time. So that's what's significant in our review of the medical examiner's report. Stepping back from that, we then asked independent experts to review the case. So as early as I received the reports from DCI in August, as early as September, I had requested an examination by a local use of force expert. That was Lieutenant Pat Martin from the Greenfield Police Department, state certified use of force trainer, works at MATC as well. He conducted that review, but at his suggestion, he recommended that I also obtain the insight and advice of a national expert completely removed from any influence of Wisconsin law enforcement. I did so, consulted with Mr. Capelson, and Mr. Capelson then agreed to take the case and in September of this year. He arrived in Milwaukee for 2 days in November, where he walked the scene. He met with all the investigators. He met with the medical examiner. He did an extensive review of all the evidence in the case, and he spoke with Officer Manny, with Mr. Manny's attorneys present as well. And then I received his report on December 17th. Again, my obligation is to review the case in light of Wisconsin law. And I've done a detailed analysis of the law of self-defense as it relates to any individual that is put in a position where they reasonably believe that they are exposed to death or great bodily harm under those circumstances. In this case, the conclusion that was drawn in this case is, first, that there is little doubt that Officer Manny was exposed to a reasonable risk of death or great bodily harm. That then has to be assessed in the context of how police officers are trained, and not just trained in Milwaukee, but trained nationally. The standard when an officer is confronted with the risk of death or great bodily harm is that they are authorized to employ force for only one reason. They are not allowed to employ force to kill. They are not allowed to use force to wound. They are allowed to employ force to stop the threat. And as long as that threat is present, they are authorized to use force. In reviewing this case, we came to the conclusion that based on all the facts, all the circumstances present to a reasonable officer and Officer Manny's position at the time the circumstance occurred, that his use of force was privileged and was justified. I also asked one of the most experienced, if the most experienced prosecutor, certainly in Wisconsin, but perhaps the United States, Mark Williams, to evaluate this case as well. Many of you are aware that Mark Williams has headed up our homicide unit for the last 20 years. You may also be aware that Mark Williams has just announced his retirement. And one of his last acts of official responsibility for the office, I asked him to do an assessment of this case. It was his professional assessment that a criminal charge against Officer Manny could not be sustained. So reviewing all of the information, and that means all of the witness accounts, all the forensic evidence, all the legal opinions, the independent experts involved in this case, I am satisfied that we have done a very thorough, a very independent, and a complete investigation related to this. I understand that there are deep concerns any time an officer employs force. That's correct, it's reasonable, it's understandable. My obligation is simply to analyze all of those and come to the decision that I think is fair and that is consistent with my ethical obligation not to charge unless I believe that I can demonstrate a crime occurred beyond a reasonable doubt. That's what's occurred in this case. I'm confident of our decision, and I'm more than willing to take any questions that you might have related to this investigation. Yes, sir. Yeah.
14 shots fired.
We believe it was 14 shots fired. The maximum.
In order to stop an individual, 14 shots really necessary to stop an individual?
If the threat is still present, then there is no standard for how many shots you fire. So I want to make that perfectly clear as well. Again, there is no standard that says that an officer is required to stop and reassess after firing X amount of rounds. The national standard, the standard that all police officers are trained to, is that they fire to stop the threat. As long as the threat is still present, they are authorized to continue firing. And if that occurs in a relatively short period of time and the person has not reacted to the initial show of force, then the officer has continued to use force until the threat is stopped.
There are no threats on social media. On social media, there's threats now to local law enforcement of violence, killing, things like that. What would you like to say about this, and how did this weigh on your mind when you're making the decision?
I make my decision based on all the factors that I've just outlined there. That is my core responsibility. Everybody in this community depends upon the police each and every day. And we've had robust discussions, both publicly and privately, with leadership in this community where we all understand one fundamental thing, and that is that this community needs a healthy relationship between itself and its police department. They depend on them each and every day. I am not going to make the argument that police officers are authorized to use force simply because they go into areas where there's higher rates of crime or anything like that. That's a red herring that's oftentimes thrown out there. But there's a correlation in terms of how police officers are trained and what their experience tells them. And if their experience tells them that even minor incidents have the potential to become deadly in a very short period of time, they have to be trained and prepared to respond to that. Now, we can, again, have long conversations about other resources that we can provide law enforcement and other public safety services. But at the end of the day, the relationship between this community and the police department and the entire criminal justice system is essential. We are dependent upon one another. This isn't some entity. The police department isn't some entity that exists outside all the other institution and vital entities within this community. They are part of the community, and when incidents like this happen because of historical injustices that have occurred in the past, people are rightfully concerned. That's where it's my obligation to assess this as objectively and fairly as possible and put all this information out. I think that if the public reviews this information, looks at it carefully, and understands all the dynamics in place, they'll believe that we've made a fair decision. Those that don't will never believe that, but I understand that. So it's our obligation to come together as a community and address all these problems in as positive way as possible. Making threats against police officers isn't going to solve that problem. It's going to exacerbate it. It's going to make it worse.
John, did Officer Manny do everything right? Did he handle this in a model way?
I would never say that any officer, much less any prosecutor, defense attorney, judge, nobody ever does everything right. That's not the standard that anybody is held to. What the standard they're held to is that, given the facts and circumstances, they behave as objectively reasonable as they can behave in that circumstance. Now, for example, my decision has nothing to do with the initial encounter with Mr. Hamilton, right or wrong. That's a decision that has been made by the police department. That's a decision that may very well be the subject of civil litigation. It may be the subject of a review by the federal system. That's not what I do. What I do is make a determination whether Officer Manny's conduct was privileged in the performance of his duty on that particular location with the facts and everything that I have. So in brief, I'm not going to say that he did everything right. I'm not going to say that anybody does everything right under these circumstances. But when it came to the actual use of force, as highlighted in the Capelson report, what he found remarkable, and he highlights in his report, is that in reviewing the force continuum basically says that, look, you have to start with the lowest level of force, which could simply be wearing your uniform and walking up to somebody and saying, don't do that. If it results in resistance or evolves into combat, then you have to go to an intermediate level of force if that's appropriate. That happened in this case. If that doesn't work, you have to make the decision whether you have to escalate it to potentially lethal force, and that's what's happened. So in the Capelson report, what he will tell you is that he saw him go through the entire force continuum in this particular incident, which doesn't happen in all these cases. Sometimes you go from the lowest level to the highest level, and only a matter of seconds transpire. So simply all I'm saying is that from the legal standpoint of assessing whether or not under these facts and circumstances he was confronted with a situation that posed the real threat of death or great bodily harm, and was he justified in using force in this circumstance, and was the amount of force appropriate, my conclusion is yes.
John, are you concerned this is a new standard for the time and the number of experts it'll take to review every subsequent law enforcement case?
Well, sure, Bruce. I mean, this is a good point. So this office has a history of trying to make these matters as public as possible. We've over 40 years did inquests on almost every single one of them. That turned out to be a very dissatisfying thing for the public, because rarely, if ever, did an inquest recommendation come back recommending charges. I've tried to do open John Doe hearings in certain circumstances. I have employed the inquest myself. No matter what you do, in my experience, no one is ever going to be satisfied. Because there's just a fundamental tension that has always existed, and that is that as the chief prosecutor in this jurisdiction, I have to work with police officers each and every day to serve the community and serve victims. When an officer is then in turn accused of a crime or involved in an incident that has to be reviewed, there's a presumption that we can't be fair and independent. And so this was really the subject matter of the recent legislation. So legislation is trying to address that issue by first requiring that there be an independent lead law enforcement agency. And it's just that. They're the lead law enforcement. It's not, depending on the circumstance, it's not even possible for them to take over the entire investigation and seal everything off. Certainly you couldn't have done it in this particular case. But the intent of that legislation was to introduce as much independence as possible. If you'll recall, there was also a recommendation that there be an independent review panel. That was shot down. There was a recommendation that someone besides the local DA make the final decision. That was shot down. At the end of the day, it's my obligation, it's my duty, and it's my job to make these decisions. Until that law is changed, that will always be my responsibility. I embrace it, I accept it. I knew it when I was getting into the job that issues like this would attract an awful lot of deserved scrutiny and concern. But the reality is that to address that, I've tried to insert as much independence. What do you lose with independence? You lose control over the timing. It's as simple as that. I know that there's been concerns about the length of time that this has taken. But as I said, I would report out to the public as soon as the investigation was completed and an independent expert had weighed in on this. As far as the standard, I hope it's a new standard. I hope that you look at the Capelson report and you assess it in light of any other shooting investigation that's been done in the state of Wisconsin before. Take a look at it and ask yourself if it's not thorough, if it's not professional, if it's not independent. I think you'll find it is. And if it becomes the new standard, that's good. But understand that there's some downsides to that as well. And certainly the downside is it takes more time to get the answers that we want sometimes.
John, you showed in the illustrations all of the different injuries sustained by Mr. Hamilton. What evidence did you have, if any, of any injury sustained by Officer Manny, and what role did that play in the investigation?
No, it's an excellent question. Officer Manny, through his attorneys, agreed to provide his medical reports, and those medical reports do document that he suffered injuries. Certainly the injuries that were treated initially at the emergency room that same day, and since that time he's received treatment for head trauma-related injuries as well. So he continues to receive treatment for those. Those were backed up by his medical papers.
And you mentioned something about the timing. You got the report from the DCI on August 8th, so that's about 4 months ago. What was it that finally gave you that confidence, as you mentioned, to make this decision? And was it any particular report, any particular piece of evidence? And when did you finally make that decision?
Sure. The crucial piece of the investigation that I was waiting for was the Capelson report. In other words, the independent expert from Pennsylvania, waiting for that report and for his summary, in addition to all the other evidence that we continued to look at from day one. So there's no question that final opinion is significant. Why is that? I just simply have to explain from a practical standpoint, and that is, were I to ever elect to charge a police officer, change the facts even a little bit, regardless of that, I would be required to bring an expert in to say that what that officer did under those circumstances was not according to training and was not justified under use of force law. You would have to do that. We do that all the time. Many of you remember we've just recently completed trials against police officers where they've been accused of, for example, battery to a police officer, where on videotape you have an officer allegedly slamming the prisoner's head into a concrete wall. Remember what the verdict was on that. That was a fully videotaped incident. They found the officer not guilty of the battery to a police officer. They found him guilty of misconduct, but not guilty of the battery. Why? Because the defense brought experts in to say that was actually an authorized trained technique. We brought our own experts in to say something different, but at the end of the day, the jury concluded that the officer was not guilty of that. You have to do that on each and every case that you look at, and that's why an expert's opinion is absolutely critical in a case like this.
John, could we talk about that misconduct aspect and go back to actually the the point at which Officer Manny decided to pat down Dontre Hamilton. And he can't just pat down anybody, right? There has to be a reasonable
That's correct.
suspicion that he's armed and dangerous. So could you talk a little bit about whether there was a reasonable suspicion he was armed and dangerous? Was it a good stop? And if it weren't a good stop, couldn't you be charging him with misconduct in public office as you did the officer with battery, a dual charge like that?
No, and first and foremost, my assessment does not make a determination whether the initial stop was justified or not justified. What I thought was significant, again, was the reason for the dispatch, and it's included in the report, right? So there's a significant difference between being dispatched to a trouble with subject, in which case Fitchett and Forte respond to that incident, and they have a conversation with Mr. Hamilton. They determine that he is not causing a disturbance, and they leave. Officer Manny, who's assigned to that, and his assignment is to deal with low-level public nuisance complaints, his dispatch is to a homeless person sleeping in the park. There's actually an ordinance that prevents people from sleeping in county parks. You can be summarily arrested for that. So that puts you in a different posture right from the. I'm not saying it's justified or not justified, but in that context. Secondly, if you were to charge misconduct every time an officer mistakenly makes a discretionary decision on when to pat somebody down or not, the consequence for that is clearly established in law right now. The consequence for an illegal search, for example, or an illegal detention, it's suppression of the evidence. The person can't be charged with that crime. I don't know of any police officer that's ever been criminally charged for misconduct for making the wrong discretionary call that they had a reasonable basis to pat somebody down. Because remember, these decisions occur in very fluid environments and sometimes with very limited information. It doesn't justify an unlawful pat down, but it simply says that the consequence for an unlawful pat down is suppression of that particular evidence. Final point, and it's in the report as well, and that's State v. Hobson. Since 1998, the Supreme Court of Wisconsin has held that a person does not have a common law right to resist even an unlawful arrest. So you do not have the right to actively resist a police officer, even if the officer is completely wrong. Now, the Supreme Court looked at that issue very, very closely. And what they determined is that the law has changed so dramatically, and there are so many remedies available for people that are wrongly detained or who are improperly searched. There's peaceful remedies for that. What they said is that the person has to submit to that and that the remedies can then take place. You now have Riverside reviews within 48 hours. You have the ability to administratively complain. You have independent prosecutors that review the case, and oftentimes no process cases because of Fourth Amendment violations. You have civil rights opportunities if you believe that your rights have been violated. But you are not allowed to physically resist an officer just because you believe that you've been wrongfully detained. So that's my assessment.
Could you just explain your analysis on why this was not an unnecessary use of defensive force?
Right, and that goes right back again to assessing how officers are trained, how they're equipped, and the assessment done in terms of, as we demonstrated, how quickly these situations unfold. And again, as long as the officer is confronted with a situation that you can reasonably say still poses the threat of death or great bodily harm. And again, the Capelson report goes into great detail that explains that in this short period of time, it often takes a level of reaction. So even once the threat is over, it takes time for that officer to assess that. In this particular case, according to the citizen witnesses that saw the majority of the incident, the officer stopped firing as soon as Mr. Hamilton went to the ground. So with Mr. Hamilton on the ground, the firing stops. As long as Mr. Hamilton was standing and was armed with the officer's baton and had used that against the officer already, he would be justified to employ force. And then unfortunately, you can't say that one shot was appropriate, 2 shots appropriate, 6 shots appropriate, 10 shots. You just have to base it on the circumstances that the officer confronted at that time. But there is simply no standard that says, what number of shots is authorized under that circumstance. It's whether or not they've stopped the threat.
John, did you meet with the family at all?
Yes.
Today?
Not today, no, and that was at their request. So we've met with them. They've had They have attorneys that are representing them. We've made, as we do in all these cases, as soon as the police reports and the investigative reports were available, I made those available to the family and to all their attorneys. They've been aware of that information. They did not have access to the expert's report, obviously, because that just came in recently. But yes, we met with them several times, and they've indicated that they did not want to meet with me today if my decision was not to charge Officer Manny.
Do you think your expert gave this case high enough priority? It sounds like 5 weeks between when you contacted him or contracted with him and when he visited Milwaukee, and another 5 weeks before he got you a report.
Well, I do believe so, but keep in mind that this is an expert that's testified in over 300 cases. He's been qualified as an expert in every single one of those cases. He's testified in over 50 jury trials. He was actually in a jury trial last week. So that's one of the problems that you have. If you go to an outside independent expert, to a certain extent, you're limited. I'm assuming that anybody who's hired him has an urgency as great as ours. It's as simple as that. And so he has to put it in line with the other cases that he's reviewing. And he doesn't take a lot of these cases. He was intrigued by the facts in these circumstances, and after discussing it with us, agreed to take the case. This is a very practical concern, but in line with Bruce's question, no additional resources have been provided to insert this level of independence into the investigation. It's something we're going to have to look at. This is yes, yeah. So we have a limited budget to use for expert tests, Chapter 980 cases, things of that nature. This is a very expensive process.
How expensive?
It's going to be in excess of $20,000. And so that has to go through a county contracting process. These are all things that this is getting in the weeds a little bit, but it's a reality that you're faced with. If you want to insert true independence into these investigations, we have to be prepared to do things differently and to resource them differently.
How much weight did you place on Officer Manny's own account of what happened?
No more than any other witnesses. In other words, when you're assessing any witness, you assess it from the standpoint of were they in a position to see what they saw, and can they accurately recollect and recount what happened. Certainly, Officer Manny was one of 2 individuals that was most directly involved in it, and the only surviving one. So his recollection is important, but only to the extent that it's corroborated by independent citizen witnesses and the forensic evidence from the case. So it's important.
Communicate your decision to Officer Manny?
That was communicated last evening to his attorney.
Who's his attorney?
It's Jennifer Land.
Jack, you mentioned earlier, talking about some of the precedents that this may set. Have you consulted with Sheriff Clark or Chief Flynn about what to do moving forward, about ways maybe things could be different, maybe things that you would suggest for the department, their training, and have you consulted maybe with even state leaders who might look at changing some laws?
The answer is I have, in fact, consulted with Chief Flynn. Let me just simply make the point that Mayor Barrett, Chief Flynn, and other community leaders have gone to great lengths in the last 6 months to publicly address this issue. Everybody understands its importance. They've gone to great lengths to meet with community leaders. I have done the same. And the uniform message that I get from everybody is that we're deeply concerned about this, and we want to change the dynamic, not just related to officer-involved shootings, but to the level of violence that's occurring in the community as a whole. The two are connected only in the sense that I indicated earlier. It's not an excuse for police use of force. It's simply a reality, a fact of life. That they have to be trained to a certain standard based on the objectively reasonable threats that may be out there. So the commitment that we have as community leaders is to do everything we possibly can to reduce the conditions that result in encounters like this or result in violence in the community as a whole. And we're taking great steps to do that.
Are there any specific ideas or instructions in those conversations? Because one thing to have kind of community outreach and all that, but what specifically are you telling Chief Flynn or telling Sheriff Clark or telling local leaders at the state level who are in charge of legislating what to do now?
Well, my personal position is this, and it's just not my personal belief, it's what I've acted on, and that is that ultimately once a problem comes to the courthouse, it's generally too late. So one of the first things we have to do is change the way we operate in the criminal justice system by becoming more directly involved in the circumstances and the dynamics at the neighborhood level. That's why we've developed a nationally recognized community prosecution program. That's why the police department is committed to nationally recognized community policing efforts. All of those are designed to establish relationships with real people in real neighborhoods and develop working relationships that are focused on solving problems. We're trying to redesign things within the criminal justice system so that we're not taking a one-size-fits-all approach to everybody that comes in. We certainly are deeply concerned about disparities that exist in the system. We're having deep discussions about that both at the local and at the state level. We need additional resources to deal with the mentally ill and the drug addicted in this community. There's no question about that. If police officers are the first resort for the mentally ill, you are going to have encounters like this. I've done over 100 either use of force or officer involved or in custody deaths. The percentage that involve the mentally ill is always high, and it's always tragic. So the commitment that we have to make as a community, and we're working very hard on doing that, is to get to the individuals that need our help before they're in a crisis and before something like this tragedy occurs.
John, you don't operate in a vacuum. You saw the way prosecutorial decisions like your own have been received in other cities. The Hamilton family expressed concern and frustration that now it had come to the week of Christmas for this to happen. Did you give any concern or consideration to the fact that this could spark those kinds of protests the week of Christmas?
You know, the obligation I had in light of everything that's occurring, again, I can't control outside events, and I can't allow outside events to control me. The commitment I had made was to make a public report as quickly as possible. And quite frankly, delaying this any longer, I don't believe would have served the community's interest. And so the obligation I had is, as soon as I had all the information I need to go public with that, as I indicated I would. Delaying it any longer, I just don't think serves the public's interest. My decision is out there. It can be examined. I can be criticized. People can take whatever action they think is appropriate based on my decisions. But this is now the time for us to move forward.
John, how much do you think if Officer Manning was wearing a body camera, would that have helped the process? Would it have expedited the process, do you think? And would you like to see a push for officers wearing body cameras?
So when I talked to the national experts from law enforcement, they just acknowledged that body cameras are coming. Okay, they're coming. Just as 10 years ago, the big push was for dash-mounted cameras. That's standard operating equipment. So yes, I anticipate that that's just going to be standard equipment in the future. But let's not fool ourselves. Just going back to the point I made before, and that is, that's not going to be the be-all, end-all. That's not going to solve it. So you're not always going to capture what you need to capture, and you're still going to need an experienced human being to describe what's taking place in the context of a law enforcement encounter. How are they trained? What are they responding to? Is it consistent with its training or inconsistent? It's very, very hard to charge a police officer with homicide if he does exactly what he's trained to do.
Based on a couple of questions about the altercation, did you talk about Officer Manning's injuries a little bit more? Because some of the street protesters would suggest he wasn't hurt all that badly. And then second of all, sorry if it's a cliche, but did he say to Dontre, stop or I'll shoot?
Yeah, it's in the report, but I probably didn't highlight it enough. Multiple witnesses heard multiple verbal commands throughout the entire encounter. So it was stop, get down, just the variations of that throughout the entire portion of it. And then what was the first question?
The amount of wounds or the wounds Officer Manning.
Oh, yeah. Right. So what he did suffer is he had visible redness to the neck area where he was struck with the baton, and the follow-up to that indicated that he was being treated for traumatic head injuries. He also suffered, I believe, rotator cuff injury, a bicep injury, and then he also had a bite wound to his hand. It was described as a bite wound.
The independent expert that you brought in, did he reinforce your decision or did he change it? Meaning, when you looked at DCI's account, did you prepare a decision, and what effect did that expert have?
No, I don't draw those kind of conclusions until I have all the information I need, because obviously you assess every single case and you ask yourself, what additional information do I need? Well, in this case, what I needed was a thoroughly independent outside expert. So I came to no conclusion until I had received that report. And keep in mind, the deal that we made was that he comes to whatever conclusion he comes to. Clearly, if he'd come to the conclusion that Officer Manny's use of force was not consistent with his training and was not in accordance with the law of self-defense, that would have weighed heavily in my decision. If for no other reason than this, I would then have an expert that would support a criminal charge at that point in time.
The timing of the announcement this morning, did it have anything to do with what happened over the weekend in New York or Florida, that there may be more sympathy for police at this point?
No.
That would sort of mitigate reaction today?
No. Look, all I can tell you is that we played this straight up from the beginning. There's just no way you could ask that same question a week ago. You could have asked the same question when this occurred, obviously before Ferguson occurred, and I didn't change the timeline to the extent that I could control the timeline because Ferguson occurred, or that you had the release of the grand jury decision in New York, or you had the incident in Cleveland, or you just had the recent incident with a police officer shot in New York. The only thing that's changed, right, is that there's now national awareness that this occurs in every major city. Keep in mind, look at those other cities. Look at the number of use of force in some of the other cities, particularly cities that are currently under federal consent decrees, and then compare it to Milwaukee. That's all I can ask you to do. Is it a serious issue? You bet it is. Do I take it serious? I have been on call for 8 years straight now. I respond to every single one of these with my investigators. Why? Because I always felt strongly that there had to be that element of independent review. Even though people challenge how independent that is, somebody still had to do it. So I've been on call for 8 years straight. I will respond and have responded to each and every one of these things. So we take them serious. We take it serious, and we try to respond as appropriately as we possibly can. Yes, sir.
Could you clarify why the outside investigators brought in under the Bell Law had such ties to MPD?
No, I can't, except to say they clearly did. Once somebody is employed by a separate agency, that's who they respond to. The DCI agents respond to the Attorney General. Now, in practical terms, the DCI has jurisdiction for the entire state. They are commonly used in smaller counties, medium-sized counties, to do the entire homicide investigation themselves because they don't have the expertise or the experience to do so. It is only natural that when trying to select somebody that can fill that need outside of Milwaukee, where we have lots of really experienced homicide investigators, unfortunately, and very experienced homicide prosecutors, when you have to fill that need in an agency like DCI with statewide jurisdiction, they naturally go to people that have 20, 25 years of homicide experience. And when something like this happens, they go to those people to conduct this investigation. It only makes sense. I will just tell you that I saw nothing. Part of the delay is that they spent hours and days and a month going through every single report, every single audio of every witness, every video of every witness, all the forensic evidence. They went through every single bit of it. They did corrections, they did additions, they did additional investigations related to that. In my opinion, they were completely independent and completely professional. Nothing in their reports. And again, that's why I didn't use them as the experts in the case. I didn't ask them to render an opinion based on their investigation, which I've done in the past because they weren't part of it. I think that they did an exemplary job. I think that they were completely professional and independent in this case. But yes, some of them have ties to the Milwaukee Police Department, as does every other law enforcement agency in the county.
John, you're not a robot. You're a human being with feelings and emotions yourself. You have a family. How much is this worn on you personally, and are you concerned for your safety, your family's safety moving forward?
No, I'm never concerned for my safety. Like I said, I'm a volunteer. I believe strongly in the mission of the DA's office. I believe in treating people fairly. We treat them, keeping in mind our obligation to keep them safe, preserve their civil liberties, treat them with compassion, treat them with dignity. No, I'm not. This is my job. I'm proud of the work, not only that I do, but the people in my office do. So I am not concerned about my safety in the least bit. I've received expressions of tremendous support from the people that are deeply concerned about the relationships with the criminal justice system, and they want to move forward on this, and they have my full and complete support. I will do. On a human level, of course it's tragic. Anytime I have to tell a family that I can't bring justice to them when one of their loved ones has died, is always tragic. It's terrible. Our victim advocates have to deal with that dynamic each and every day. And again, that's where the reason that our job is unique is our obligation is not to tell people necessarily what they want to hear. We have to follow our ethical obligations in the law, and sometimes that's very difficult. Sure, it takes a toll on you that way, but it's a privilege to be able to do the job, and we're committed to doing it the right way.
And I have kind of a silly question moving forward. If there are protesters who are arrested and charged with state charges as opposed to citations, who are protesting your arrest, does that create a conflict for your office to prosecute them?
Protesting my decision,
Yes.
and their arrest, it could be, and so we've certainly in other historical contexts brought people in. For example, we've used the city attorney to review a number of the cases. I don't know if that would be appropriate under the circumstances, but we can certainly address that issue, and we do so in the regular course of any case. If we think that there's a potential conflict, we take steps to address that issue. But it's a good question and something we'll look at.
John, the Hamilton family's attorneys, they mentioned that they thought you were also consulting a federal use of force expert. Was that?
So the FBI and the U.S. Attorney were provided with the materials as well. We were informed that they were conducting their own review, but they can give us no timeline for when they're going to come to their decision. And as I anticipate, the venue will move from the state level to the federal level next. But yes, they're assessing it as well. I will say that I know almost for certain that nobody from the federal side has done the kind of work that Mr. Kappelson has done in reviewing this case so far.
Would
Yes.
you recommend that the Bell Law be passed, something similar for other states?
I think the more independence that's inserted into police-related fatalities, the better. But at the end of the day, you have to come up with, I said this back in 2007. Remember when I first took office, it was post Frank Jude, and people had deep concerns about police community relations at that point in time too, and had some significant police-related fatality cases that were drawing some concern. I said at the time that the only way that you'll ever address this problem is to have a completely independent law enforcement agency reviewed by a completely independent prosecutorial agency. It doesn't exist anywhere in the country. I would, to the extent that you have the accountability that you need. So at the end of the day, despite what I will presume will be some very unhappy people with my decision, it's my decision, and I'm accessible. I'm locally elected, and so there's a consequence. When you remove that accountability, you have less control. So that's the choice that people have to make at some point in time. I support independent, thorough investigations. I believe we do that, but at the end of the day, if that's the direction people want to go, then they have to have a very, very thoughtful discussion about it, because it doesn't solve all your problems.
Does the independent review make any sort of determination whether the frisk was reasonable?
No, that's something that I addressed a little bit earlier, and so no. It's certainly part of the facts that I have to review, but I don't make a determination in this case. Had it gone differently, and let's assume that there had been no fatal encounter here, no use of force, then we would, of course, say some contraband had been recovered or something like that. Then in the regular course of it, we would analyze whether the frisk was justified or not. But we don't do that in this particular context, as I indicated before, because even if the frisk was not justified, it didn't authorize Mr. Hamilton to forcibly resist that encounter with the officer.
Did Mr. Hamilton say anything during the course of all this?
There's nothing in the reports that indicates that he made any statements at all. It's a good question, but
Hamilton never spoke.
No, except for the very brief initial encounter. I don't believe there's any verbalization between them. Thank you very much. I appreciate it.
Thank you.
District Attorney John Chisholm, in about an hour's worth of analysis, offering how he reached the decision not to file criminal charges against police officer Christopher Manny in the shooting death of Dontre Hamilton.